Hello, everybody. It's Teresa Shaver from the Business Advisory Center, Durham, and I'm here today with Bereskin and Parr, who are a member of our expert network. And we've got some extra special things in store for you today, because not only are we just talking to them about their organization, but they're even going to give us some knowledge and some information about intellectual property and copyrights and trademarks and that kind of thing. So I'm going to hand you over to Catherine Lovrics from Bereskin and Parr, and she's going to tell you a little bit about herself and her organization, and then we'll have the pleasure of listening to you. Thank you, Catherine.
So thanks very much, Teresa. My name is Catherine Lovrics. I'm a partner at Bereskin and Parr in our Toronto offices. I'm here today with my partner, Toni Orsi, who's also a partner in our Toronto offices. And we're very pleased to be here today to speak to you about intellectual property matters generally.
Thank you.
Thank you. So to kick it off, no legal presentation would be complete without a legal disclaimer. And so to state the obvious, this presentation does not constitute a solicitor-client relationship, but rather serves as a guide, and we're not actually providing legal advice today. It's important that for any specific legal matter, you get advice that's tailored to the facts at hand.
Thank you.
Thank you.
Glad that's clear.
Okay, so what Toni and I were going to talk to you about today, just very generally as an overview, we'll kick off with a very basic introduction about what is intellectual property, what's protectable. We'll talk in a little bit more detail about different types of IP and different areas of IP, including copyright, trademarks, industrial design, and patents. And we'll also touch a little bit on agreements, licensing, and clearance issues, which are very important to know about. We'll close with some high-level do's and don'ts. For this presentation, there's no time for questions, but if you're a member of the audience, feel free to reach out to either Toni or myself or any other member of our firm with any follow-up questions.
I will make sure that I have your information in the show notes, also linked to this presentation. So thank you for sharing that.
Perfect. Thanks, Teresa. So why should you care about intellectual property? In a nutshell, intellectual property serves as a valuable asset for your business. Your IP rights can be used to set your business apart from your competitors. They can be purchased, sold, or licensed and provide a revenue stream for you. They can be used as security for loans, used for funding and grants. They can simply offer customers something new and different, and intellectual property gives you the ability to protect that new and different and claim exclusive rights over it. And it can form an essential part of your marketing and branding.
Right.
So very basically, the different areas of IP are copyright, trademark, industrial design, trade secrets, and patents. And we'll kick off today with a discussion of patents and industrial designs, and then we'll move into copyright and trademarks.
Those are the meaty subjects.
Exactly. So on the copyright side, copyright, as the name suggests, is basically the right to prevent others from copying you. And what it protects is original expressions of ideas. It doesn't protect ideas themselves. Trademarks from a 30,000-foot level protect reputations and mental links. Trademarks protect things that identify your company or goods and services as coming from a particular source. Industrial designs protect original ornamentations. Trade secrets, as the name suggests, protect secrets and confidential information. Patents protect useful inventions. What is generally not protectable? Ideas, factual informations, a simple name, short phrases, methods, generic plots, most characters, and non-distinctive titles. And there are exceptions to many of these things. So for example, for methods, and Toni can touch on this a little bit when he speaks about patents, there may be ways to protect certain methods through patents, but as time ticks, that seems to be getting more difficult.
Okay.
Ownership issues. So it's important to keep in mind that ownership is different for different types of IP, and the natural first owner, depending on the type of IP, may be a different entity. So for example, when you're looking at copyright, the author typically is the first owner unless the work is made in the course of employment. And in Canada, it's important to keep in mind that we don't have a work for hire concept, which means that freelancers, contractors, and consultants will be the first owner of copyright works unless you have an agreement in writing that assigns rights to you. For designs, on the other hand, only good and valuable consideration is necessary for ownership to transfer.
Okay.
So is an assignment required is one of the first questions that you should ask as a company when you're hiring somebody to help you create something or develop
Like
something.
logo or anything like that?
Exactly, a logo, copyright work, any sort of copy, a website. Make sure that you think about whether or not you need something in writing to confirm that you or your company are the entity that own IP rights in it. So I'll now transition to Toni and pass it over for a brief discussion on patents.
Okay, I'm also happy to introduce Toni Orsi from Bereskin and Parr. I've known Toni probably for about 5 or 6 years now. He's been coming around to BACD, he's been presenting different workshops, and he's also been part of our Do It in Durham week. And Toni, welcome. It's great to have you back again and to learn from you.
Thanks very much, Teresa. It's been a pleasure working with the BACD to support entrepreneurship in the Durham region. So we're very, looking forward to Do It in Durham week again this year.
Yes.
And yeah, definitely looking forward to helping out any way we can. So I'll talk a little bit now about patents. So basically there's two flavors of patents: utility patents, which are used to protect structure and or function of an invention. And then there's also industrial design patents, which are used to protect the look of a good. So we'll talk a little bit about each of those. So in terms of utility patents, then they would be granted depending on whether certain criteria are met. So one of these criteria basically is that it has to fall into a bucket that the Patent Office would provide protection for. And so it could be a process in terms of a method, which is maybe creating a good or maybe creating a composition. It could be a machine that has some useful function, an article of manufacture, so an end product, or even a composition of matter. And typically what you'll find is that a lot of inventions these days are usually improvements on one of these categories. So in terms of exclusions then, we would have basically abstract ideas, so things that are disembodied, there's no sort of practical physical implementation of them. So in terms of a scientific principle or abstract theory, this would be something that on its own it wouldn't be patentable, but if you were to apply it though to have some sort of benefit, some sort of physical tangible benefit, then that might be something that's patentable. Also, mere rules or schemes are not patentable. Higher life forms are not patentable in Canada. And also methods of medical treatment are not patentable in Canada, and Europe for that matter. In the States, though, they are patentable. So one thing to keep in mind then is that as you're trying to protect inventions on a country-by-country basis, different countries will have different rules in terms of what you're allowed to protect and not protect.
Okay, thank you.
So the other thing to think about for patent protection as well is that it basically provides the patent owner the right to prevent others from making, using, or selling the invention in a country where they have protection. So you do look at patent protection on a country-by-country basis, and for that reason you'd want to figure out where your main markets are and look into trying to get patent protection there. They are for a certain period of time, so it's 20 years from the filing date. And basically it's sort of a race to the Patent Office in terms of who's able to get the earlier filing date if there's two different parties that are trying to protect the same invention. In terms of going through the process, you put together a patent application, which is a document that has text and figures, which describe how the invention is structured and how it functions. And then you'd have these claims at the end, which describe the protection that you're trying to pursue for the invention. And this patent application is published 18 months after it's filed, so it's important to consider that as part of your business strategy in terms of trying to protect something via patents, or maybe trying to protect it through trade secret.
So it's not something that's overnight. It takes quite a while to get this done.
Yes, you're absolutely right. So yeah, in terms of actually preparing the patent application, yeah, it could take several weeks or maybe a couple of months to prepare a very good patent application. And then once it gets filed, there's, it goes through the process of the Patent Office, and depending on the technical subject matter of the invention and the country that you're filing with, there's different degrees of backlog. So it could take about 2 to 3 years, or maybe even more, to get an issued patent. So it's important, it's important to think about that from the point of view of your product's life cycle and whether those align or not.
Right.
So yeah, as I mentioned earlier, there's several criteria that have to be met in terms of being granted a patent for an invention. So the first one we touched upon, patentable subject matter. One area or aspect of that, which is also important these days, is software-based inventions. And so, you could be looking at software methods for doing a certain thing. And as Catherine had mentioned, it's much more difficult these days to get software patents granted in the US and Canada. So when it comes to software-based inventions, we really need to dig into the details in terms of what's being done and make it as technical as possible. And hopefully that also covers the sweet spot in terms of what the competitive advantage of the company is in terms of trying to protect it through a patent. Another criteria is novelty. So basically you'd compare your invention to what's been done before, which we refer to as the prior art. And you'd have these features or elements or aspects of the invention which you think are unique. But when it gets examined, an examiner will search for any publicly available document anywhere in the world to verify whether those items in the claims actually are novel or not. And so it's a good idea to try to do some searching on your own if you can. So definitely the more you know what the prior art, the better position the patent application can be, and can give you an idea of what sort of amount of protection might be available, which could have an influence on whether you proceed with protecting it via patent or not. Another aspect, in terms of comparing your invention to the prior art, is to determine whether it's obvious based on what's been done before. And so this is a little bit different. So for novelty, it's pretty much black and white. Either these features are in a previous document or
Right.
not. And with obviousness, it's more subjective. And so the question would be whether somebody who's skilled in the arts, if they looked at 2 or more documents, whether it would be obvious to them to combine them to come up with what you want to protect. So that's also something that has to be carefully considered before you embark on the patent process. And we definitely look at what the advantages of the invention are to get some ideas about whether you meet that criteria or not. And then finally, the invention itself has to have utility. So basically it has to work and it has to perform a useful function.
Right.
Alrighty. So
Very technical.
Yes, very technical. That's right. Sort of the more less exciting part of IP protection, I guess, in terms of patents.
Good point. Everybody much prefers all the design and copywriting and trademarking.
Right. Yeah, we're getting more creative now, so the more interesting part of the presentation. So yeah, moving on to the other type of patents, so industrial design patents. So here, basically, as we said before, you're trying to protect the look of an article. So it could be something that's, a physical product, or it could also be something which, is on a mobile device. So basically a graphical user interface or icons, even in terms of a laptop as well, some sort of a layout for a web page, for instance. Those are things as well that you can try to protect with industrial designs. And so here it's sort of similar in terms of the utility patent applications, where you have to put an application together which describes the design. So basically it'll be a collection of figures which show the design from different angles or views, as well as shows different variations of the design if possible. This also has a lifetime tied to it as well in terms of the registration. So it would be the longer of 10 years from filing, from registration, or 15 years from filing. And basically here, the right is a little bit different in the sense that with the utility patent, it's more of a negative right to prevent others from doing certain things. Here for the designs, basically it provides the right in a specific country for a certain period of time to be able to make, import, sell, or rent any article to which the design or something very similar to that design has been applied. So basically here, the thing to think about as well is that the design itself has to be kept secret before that application is filed in many countries around the world. Canada, though, does give a grace period in case there is public disclosure. So if it has been publicly shown on a website or some other publication, for instance, or even during a trade show, you've got 12 months to then file an application if you want to protect it. And the same also goes for utility patents as well.
Before you move on to the next, I have a question for you. So I saw those 2 little drawings on the slide, and I know for our listeners, they won't be able to see them.
Right, okay.
One is a Chanel purse, and one is a perfume bottle from Kat Von D.
That's right, yes.
And so the question I have for you, I mean, if somebody has a product, it's not necessarily that simple to go about. You can first do the industrial design, but where does it give you protection? Only in the country that you register that industrial design in. Is that correct?
Yes, that's correct. So yeah, it's also on a country by country basis in terms of protection, although there are some regions which are I guess members of a larger organization. So for instance, in Europe, there's a European design that could be pursued, which would potentially cover, I think, up to about 35 countries.
Oh, cool.
Yes, yeah. So here, I guess the interesting thing here is, as you're looking at protection throughout, the, I guess, product design cycle, it could be possible to use both the utility patent and a design patent to protect something that's produced. So yeah, that's something to keep in mind as well.
And then the other thing I noticed is that the term is only 10 years or 15 years and then it's done. And can they apply for an extension or no?
No, they cannot apply for an extension. There is a renewal fee as well, depending on the country, that they needs to get paid to keep it in force. So again, you look at whether that lifetime kind of matches up with the product life cycle as well, in terms of whether that makes sense.
I wonder, because there's been so many knockoffs of purses like Chanel, right? So how are they enforcing?
Well, so the thing is, in terms of IP rights, you basically engage the Patent and Trademark Office to get these registrations, but then it's left up to the owner, the applicant, the owner of these registrations, basically to police the marketplace and find the sort of infringing activity and then take steps to stop it from further continuing.
Excellent, thank you.
I think with that, then we can move on to copyright protection.
Okay.
And get Catherine back here.
Okay, so thanks so much, Toni. We'll now transition into copyright.
Thank you.
So to kick off, copyright arises automatically. You do not need a registration for copyright protection. Copyright also, generally speaking, will extend internationally without needing to do anything by virtue of this treaty system. And there's some nuances to that, but that's sort of the big picture. You don't need to register, arises upon creation, and will extend to other jurisdictions.
Okay.
So copyright is more than just the right to copy. It allows creators and owners to control a bundle of different rights, including publishing something, as I said, copying, communicating it over the internet, or altering it, or distributing it. And copyright is generally divisible for the purposes of exploitation. And what that means is that if you are, let's say, licensing some media, you can license it specifically in a particular jurisdiction. So only in Canada. You can license it only for a specific right. So let's say you're licensing some video to some audio visual thing that you've created. You can license it only for use on the internet or only for use in a particular medium. Or if you've written a book, you can license a particular set of rights and not everything. So what does copyright protect? Copyright protects works. And what are works? Works can be literary, and that includes books and copy, website copy, marketing copy, and it can also include software code. So somebody codes and writes the code itself is considered a literary work and will be protected by copyright. Copyright also protects dramatic works, and it protects musical works.
Okay, good.
In addition, it'll protect artistic works, and that means if you have a very artistic logo or design, it'll protect that. It also protects photos, drawings, maps, charts, plans, sculptures, and if there's any architects or builders in the audience, it also protects architectural works. It can protect compilations of works, and that means, let's say you have a website. A website will be a compilation of a whole bunch of different works that come together. You'll have the code that underlies the website, you'll have graphics, as well as written copy and advertising copy, and all of that collectively is treated as a compilation.
Okay, good.
So as we mentioned at the beginning, copyright and IP rights generally don't extend to certain things. So facts, themes, ideas, generally there's no copyright protection in those things. Copyright only protects the expression of an idea and not the idea itself. So it will protect the way that you have written an idea down and the specific wording that you use to express that idea, but it won't protect the underlying idea or the facts that are reflected in whatever it is that you express. And to be protected, the work must be original, and that means it originates from a human author, and it's the product of that author's skill and judgment. And so originality in Canada is sort of in between the originality standard and other jurisdictions. In the US, for copyright to subsist in a work, there must be a spark of creativity, and in the UK, all you need to do is basically exercise some labor and effort to create it. In Canada, we're sort of between those two standards. You don't need any creativity, but you do need more than effort or labor, or sweat of the brow is the legal term that gets used. And what that means is in Canada, there's opportunity to protect things like databases or other things that may not be viewed as traditionally creative, but are certainly valuable and worthy of protection, and copyright will lie. In the UK, copyright is even wider and will apply to things that are neither creative nor involve the exercise of human skill and judgment, provided there was a level of labor and effort that goes into creating them.
Excellent.
The other thing that's required for copyright to subsist, and this links back to the idea that copyright doesn't protect an idea, is that you actually have to express something and fix it into a physical substrate for copyright to lie. There's some exceptions, so there is something called neighboring rights that protect performances, but generally speaking, on the work side, it must be fixed. And what that means is if you're in a room and you're talking to a bunch of people and you have a great idea and you say that idea, but you don't actually write it down and they don't review a written expression of the idea, there's no copyright that attaches to your having said that idea, and there's no claim that will flow from that. Originality. So copyright subsists in every original literary, dramatic, musical work. As I said, copyright protects works that result from skill and judgment. Now, basically, what that means is you cannot have copied something from someone else, and you need to have engaged in some intellectual effort for copyright to subsist.
The question I have for you, when can you use the C symbol? Because I don't see you mention that.
Oh, that's a great question. So first of all, there's no obligation to use the C symbol, but it is advisable to use because you're putting people on notice, and specifically on notice of who the owner is.
Okay.
If you are confident that you are the owner of a copyright work, you can put it on pretty much anything. C followed by the year that it was first published, followed by the owner's name, with a statement like all rights reserved if you don't want anyone to do it. Or there's also the emergence of copyleft type notices where you give certain permissions. So there's an organization that runs a Creative Commons program, and if you're interested in embedding digital licenses that give some permissions but not other permissions, that's an organization that's worth looking into.
Okay, that's good to know, because I think people weren't sure when do they use that symbol, right? And
yeah, so and I think that you do need to, on the copyright side, there's less risk of using the symbol. On the trademark side, I think you need to be a little bit more deliberate about when you're using the TM symbol and when you're not using the TM symbol, and that's because you don't want to get into a place where you're alleged to have be using a trademark that is confusing with someone else's trademark.
fair enough.
Okay, so general term of copyright. How long does copyright last? A pretty long time. So in Canada, generally, the term of copyright is the life of the author plus 50 years after the year of that author's death. In the US, it's life, and Europe, it's life plus 70. And in fact, this past year, Canada committed to extending our copyright term to life plus 70 years. That hasn't been implemented yet, but we do expect to see that be implemented in the future. So moral rights are sort of an adjunct to copyright, but they belong only to the author. And moral rights very basically are the right, where reasonable, for the author to be named as author or to remain anonymous if the author chooses to remain anonymous. They're the right also to control the integrity of a work, and that means to prevent others from changing the work in a manner that would be considered prejudicial to the author's reputation. And to be clear, that test is not, you know, you're the author and you believe that the integrity of your work has been affected. It's more of a subjective, objective test.
Right.
It's also the right to prevent a work that you authored from being associated with a product, service, cause, or institution that would be prejudicial to your honor or reputation. Moral rights can only be waived. So the key here is whenever you're retaining someone that will write or create something for you, it's important that they waive their moral rights. Otherwise, there is a risk down the road that you will either need to name the author. So if you retain somebody to write an article for you, for example, you want it to be abundantly clear that you don't have to put in a byline for that person, or that you do if that's the deal, but you want to turn your mind to that. And there's also a risk that you may be prevented from altering the work, or possibly, depending on the circumstances, from preventing the work from, the author may be able to prevent you from associating their work with a particular product or service, which could be risky. So turn your mind to moral rights, get a waiver from the author. So what is infringement? So you think somebody has taken something that you have written and you want to go after them. What's the test? Generally speaking, well, not generally speaking, infringement is or does lie when anyone has taken a substantial part of the work and there's not an exception or a user right that allows them to do that. A substantial part is not a 50%, it's not a number. It's a qualitative assessment, it's not a quantitative assessment. And generally speaking, you could have infringement lie where you take one single line or a very small part if that part is very important to a work. It's also possible for infringement to lie when in fact there's been no direct reproduction. So if nobody actually, you know, right clicks, copies and pastes, but they take a look at your work and they what's called colorably imitate it. They reproduce the work in a way that doesn't actually reproduce a single word or a single graphic, but they're copying you. Copyright infringement may still lie. Moral rights, which we just talked about, are also separately actionable, and it's important to keep that in mind. That means that even if there's no issue with respect to copyright infringement, there may still be an issue with respect to moral rights vis-a-vis the author. What's important to keep in mind with respect to copyright damages, and in part as a nod to the fact that it is quite difficult and often impossible to prove the actual damages that will flow from copyright infringement, there's something called statutory damages. Statutory damages lie for copyright infringement, and if it's a commercial infringement, you get $500 to $20,000 for each work that's infringed. And for non-commercial purposes, statutory damages are $100 to $5,000 for all works that are infringed. This slide is incorrectly, has an error, it should say for all works. The thing to keep in mind with respect to statutory damages is that they can be a good practical thing to point to if somebody has infringed in order to get the remedy that you're seeking. And from a US perspective, there are also statutory damages, but in order to be entitled to claim statutory damages in the US, you need a US copyright registration, and the registration must have been secured before the first act of infringement. And US statutory damages are up to $150,000 per work, and you're also entitled to legal fees. So while I do confirm that copyright registration is not required, from a statutory damage perspective, it is something that's worth considering in the US in particular. When assessing what amount of statutory damages are reasonable, the court will consider the good and bad faith of the alleged infringer, the conduct of the parties before and during the proceedings, whether or not a statutory damage award will help to deter future infringements of the copyright in question, and if non-commercial, whether or not the award itself would be proportionate to the nature of the infringement. generally speaking, there is a correlation and proportionality between actual damages and statutory damages. So statutory damages should not be grossly disproportionate to the actual damages suffered by someone.
It's quite technical.
It is. Is this too technical?
I think it's, I mean, I would stop there on the technical, because I think it's a big deal for people. So like understanding the copyright, which you mentioned, and when to use the symbol, I think that's good. It's nice to know it can be enforced. I don't know how easy it is for someone to enforce it. Like, you know, one of our small businesses has someone copy something of theirs. I don't know how easy it will be to defend, and nor just like if someone in the States uses somebody's information here, how easy is it? It's not that easy to enforce, is it?
No, it's quite expensive to engage in litigation. Lawyers' fees are not inconsiderable by any stretch. And frankly, typically, when you encounter a situation of copyright infringement, what you're really focused on is getting the work taken down or having the infringement stop. And so you point to the right to claim statutory damages, or you point to the right to claim, you know, normal damages as a practical reality to try to get whomever it is that you're going after to stop the activity. Whether you actually seek or demand payment is another question, and that's not to say that you're not entitled to, but there is sort of an economic assessment that happens there. Are your lawyer's fees worth pursuing this, and what do you stand to gain?
Right. It makes total sense, and I think that's clever. You know, of course, they might not have the money, but at least you can tell them to take the information down and go from there. So yeah, that's great.
Exactly. All right, so fair dealing. So fair dealing is basically the right of others to use works without infringing them. And historically, they were viewed as a defense or an exception to infringement, and a number of years ago, the Supreme Court of Canada elevated them to the point of being considered a user right.
Okay.
They're a core part of the Copyright Act. They balance the rights of copyright owners against the rights of the public to make use of works in a way that's fair.
Okay, can you give us some examples of what fair dealing is?
Most definitely. So from a Canadian perspective, fair dealing can apply to research, to criticism, private study, education, parody, satire, and also review, and news reporting. And so what's important to keep in mind from a Canadian perspective is that in order to be, for your activity to be fairly dealing, you actually need to be doing one of these things. Fair dealing does not just blanket extend to any activity. If your activity doesn't qualify as research, private study, education, parody, satire, criticism, review, or news reporting, then you are not fair dealing. There are a few other exceptions in the Act that might apply, in the Copyright Act that might apply, but fair dealing will not. In the US, and from a US perspective, you don't need to qualify for an allowable purpose. Fair use is the concept that they have, and it's far broader. But in Canada, again, it is more narrow. And in addition to engaging in one of those activities, whatever you're doing needs to be considered to be fair. So it's not good enough to say, well, I reproduced it for education purposes. It's whether or not, the assessment of whether or not what that reproduction in your activity was fair is actually where the heavy hitting of the analysis comes. So threshold issue is, are you engaging in one of these activities? And then from there, is it fair? And frankly, fairness is a smell test, and it's often difficult to sort of put a nail down on what is fair and what is not. Typically, courts look at the true purpose of the dealing. So sure, you said you were doing it for education purposes, but was that really what you were doing it for? Were you doing it for profit? The character of the dealing, the amount of the dealing, how much of the work are you taking? And that's not to say that taking a whole work, because there will be circumstances where taking a whole work is necessary, fair, and reasonable. But you know, if it's not necessary, fair, and reasonable, are you taking too much, and does that make it unfair? Are there alternatives to the dealing? So could you have done whatever it is you want to do without reproducing this work? What is the nature of the work? Is the work of a sort that it should be widely disseminated? Is it unpublished? If it's unpublished, it may be less fair to make it available because then you're engaging another right. And what's the effect of dealing on the work? Is the way that you're playing with the work likely to undercut the market of the work or not? So an example is there was a case involving music store sampling. So when you go to one of the music stores, generally you can listen to, let's say, 30 seconds of the song. And one of the issues was whether or not 30 seconds of the song or that sampling activity itself amounted to fair dealing, or whether or not some money should be paid to the music provider, or the people that own rights in the music, or parties that own rights in the music. And in the end, the court found that the sampling was fair dealing. And part of their reasoning was because the effect on the work itself is to encourage the sale. Like, the reason you are sampling is to get somebody to buy the music, and generally speaking, it's not going to displace the market for the work. It's not like people are all of a sudden going to go to whatever your music store is and just sample music and never download another song again. It's to facilitate that market. So consider that in assessing fair dealing.
So I have a question for you before we go back to this, or maybe it goes with it. So what do people do if they're putting together a YouTube channel for themselves and they find pictures and music online? Does this fall into intellectual property, and is it legal? Is there a way around it?
That's a very good question. And generally speaking, I think one of the biggest misnomers out there is that something that is on the internet is there and free for everyone to use. That is not the case. Whenever you see anything, be it a photograph, be it a piece of written text, presume that copyright subsists, presume that there is an owner, and presume that you don't have the right to use it. Starting from that presumptive position, look into whether or not it's available under a license. So for example, if you are creating a website and you're looking for stock photography, there are, through that Creative Commons system that I mentioned, there are certain platforms that make photos available on an open basis. They are licensed to you and you can use them without tripping up. But there are also stock photography companies that only make photos available for a paid basis. And if you happen to reproduce one of those photos without permission, you may well receive a letter that demands payment.
Right. I have heard from businesses and people that these large stock photography companies have gone after some people and sent them letters and said, you've got to pay thousands of dollars for this image. Is that true?
You are correct. There are a number of businesses in the image rights management field that do just that. They represent everything from photographers to huge publishing companies. They represent a portfolio of different photographs, and they basically crawl the internet to look for unauthorized uses of photographs, and they send out letters to request payment. And that there are some companies that are in the stock photography business that have moved away from that model, recognizing that often it's really done unwittingly, and that's not the way. But there are some companies that, and frankly fairly, are in that business collecting fees. And so it is an area, especially if you're dealing with anything in digital, that you should be very, very careful about.
Right. Good point. Excellent. And so then another question I have. So if I find an image on Google and then I want to put it in a presentation, if I attribute it, is that giving license back that I can use that image?
So I really like this question because it's a great question. There's no yes or no answer, no bright line here.
Yeah.
It depends, which is often what lawyers say, but it really does. So if the presentation, let's say it's a presentation, it's in an academic setting, the photography, and actually I'm not sure if the audience can see the next slide, but this would be a good example. And the photo or whatever it is needs to be shown in order for you to comment on it. And it's an integral part of the presentation. It's used for educational purposes. It's fair, blah, 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 blah. Then probably you can use it. But if it's a name your favorite cartoon that you're including just for the sake of making the audience laugh, and it's not really to make a point, then that should be licensed. And this is very much a gray area, and these determinations do get made on a case-by-case basis.
Right.
But this next slide actually is a good example, because I am reproducing the United logo. I'm also reproducing an altered logo from a third-party website. And the reason I'm reproducing it is that both of these were used in a case, and they are necessary and important for you to see in order for you to understand what I'm about to talk about. And so I think in this context, that reproduction would be fair dealing for the purpose of education. So there was a individual that was not happy with United Airlines, and the individual put up what he positioned as a parody website that in all respects looked and felt like the United Airlines website, but he changed United to Untied. He put an unhappy face over the United logo. This is the most recent iteration. Past iterations of the website were a little bit different. And changed the United slogan to an Evil Alliance member. And the website was really intended to set up to allow for consumers to complain and express their experiences with United Airlines. And needless to say, United was not happy with this particular platform and eventually took the operator of the website to court for copyright infringement, as well as trademark infringement. This case is actually making its way through Canadian courts right now. The lower court found that this was not fair dealing. Even though it enabled consumer criticism, and even though he took the position it was a parody site, the court said that this was not fair. You're using the intellectual property of a third party to effectively criticize and attack that third party, and that crosses a line that you're not permitted to do. As I said, this is making its way through Canadian courts. Right now, this is good law, but it remains to be seen whether or not the decision gets overturned. And the decision, frankly, is quite controversial. There are those that believe that this decision the trial court decision should have been decided differently. So we'll see what happens on appeal.
Okay.
Other exceptions to copyright infringement aside from fair dealing include non-commercial user-generated content, and so that's sort of what is commonly referred to as the YouTube exception. You know, that gives the right for the mom to record her baby dancing to Beyonce song and post it online. It's not about reproducing the song. It's about
baby dancing.
Exactly. Private uses also, there's an exception for certain private uses. So that's like time shifting at home. You have the right to do that now under the Act. Format shifting, if you have your old VHS collection, you want to convert it to DVD, you have the right to do that. There are conditions, including you're supposed to get rid of the original copy, but the Copyright Act provides for that. Incidental non-deliberate inclusion. So an example of that is we are sitting in one of our meeting rooms here, and behind me happens to be the artwork that is in this meeting room. I am not positioned here to feature the artwork. It's incidentally and non-deliberately included in this particular photo, or in this particular video. Backup copies, there's also an exception for backup copies. There is a separate regime, and we won't get into the weeds here. There's a separate regime, though, for what are called technological protection measures. And that's basically digital locks and encryption and that type of stuff that prevents people from being able to reproduce or access copies of works. And it's important to keep this in mind, not only because you shouldn't be breaking these TPMs, you shouldn't be downloading illegal movies, you shouldn't be hacking into things in order to access things that you don't have permission to, or de-encrypting video games or whatever. But it's also important to keep in mind to protect your own works. This gives you separate rights and separate remedies, and especially, for example, when it comes to database protection, keep in mind what technological protections might be available in addition to the natural rights that you get. How can you technically prevent people from accessing your works, and how can you technically prevent people from making copies? And that can be as simple as a login, to encryption, to far more complicated technological protection measures that are beyond the scope of this. So when it comes to any form of IP, but particularly copyright, it's important to keep in mind the difference between assignments versus licenses. Assignments, basically, when you are assigning something, you are giving away the farm. You are assigning all ownership rights to, or you're assigning whatever ownership rights to the third party. A license is a permission to do something. From a 30,000-foot level, there are non-exclusive licenses, which means you're just giving permission and there's no other restrictions on you. There are sole licenses, which means you're only giving one license, but you still have the right to use it. And there are exclusive licenses. And I think it's very important that you keep in mind that whenever you're granting an exclusive license, you should be paying very close attention, because it means you yourself are no longer able to use whatever it is that you're licensing.
Right.
A few big picture takeaways. So first, IP don'ts. Don't assume that because you give someone credit when you copy something from them, that's enough and that'll get you out of the woods. It's not. Don't assume that because you changed 10 things or you changed 20 things or you didn't lift one word that you're not going to be infringing. That won't get you there. Don't assume that because you did it last time and you got away with it, it means you'll get away with it next time. Don't assume that because you see someone else doing something, it means that you can do it. There's a ton of infringement out there, and it should give you at best cold comfort. Don't assume, as we've mentioned, that what is on the internet is free for all to use or is the public domain. The public domain means something very different. Don't assume that, or avoid copying and pasting. Avoid the right click on your mouse. When it comes to digital, it's just too easy to copy and paste, and I think a lot of entities get in trouble with that. And generally be aware when you see somebody else claiming trademark rights or claiming IP rights. If you see a copyright notice or a trademark notice or watermarks or digital locks or something else on someone else's work, it means that they are being active about their IP protection, and you should be extra cautious.
Okay.
Do's: create original content. Don't copy people. Start from the ground up. Start from the drawing board. Be very careful with inspiration. You know, we all naturally take inspiration from the world around us and everything that exists, but it's very easy to cross a line. Clear rights. If you're not sure, get permission. Ask. Seek a license.
Okay.
Use collaboration to your benefit or get a license. And what that means is, let's say you see someone else that's done something really cool, you're in a related field, rather than copy them, see if there's a great business opportunity there where you can collaborate. We're seeing more and more of that in today's market.
Yeah.
As mentioned, get permission and credit the source where possible, and use intellectual property notices. Copyright your first publication and copyright owner. Other practical tips: what are you supposed to do when you see someone's infringing? You have options. You could do nothing. You could write to them and you can ask them minimally for a credit. You can ask them to take it down. Most platforms have third-party platforms like YouTube, Facebook, et cetera. They have their own complaint systems that you can make available, you can use for yourself, to request that they help you take down third-party material that violates your rights. Be careful, because you do need to make sure that those complaints are put in good faith. Otherwise, you could be exposing yourself to liability. Send a cease and desist letter. Let them know, hey, we noticed this. We don't think you have permission to do this. We'd like to resolve it. Engage a lawyer. And last resort is litigate.
Right. Perfect. Thank you.
Thank you.
So, Catherine, that's it?
That's it. I could certainly cover more, but that is it.
Thank you very much. What I'd like to suggest we do is that we wrap up with this session. And then I know that you wanted to talk about trademarks too. So I'd love to have that opportunity to do that on a separate interview, so that we can share that content separately to this. So I thank you and Toni from Bereskin and Parr for your time. To our audience, if you have any need and you need help, both Toni and Catherine are very helpful and able to answer your questions and get you started with understanding your intellectual property and how to protect it. So thank you again. Really appreciate your time, and we look forward to working together.